everyone. Welcome to another episode of the TCLF One-on-One Series. First of all, and at the outset, I know it's been very long and we're deeply apologetic for that, but um, we have been trying to be very consistent with our blogs and our research, and we'll try and make up for it with consistent episodes from now on. And I'm very, very glad and I'm honored to bring to you another episode with two fantastic guests who are my peers here at the Columbia Law School. And I'm very, very lucky to call them my friends, my colleagues, uh, Mr. Michael Procopio Avilar and Miss Priya Baranwal. Michael, as I've already told you, he's right now an LL.M student at the Columbia Law School. He's a federal judge in Brazil. He's a former state judge in Brazil, and he's also a former assisting judge at the Supreme Court. Uh, and he specifically uh, instructed me or told me what the role involves. Assisting judge, as at the Supreme Court, involves assisting the justices at the Supreme Court. It's the title's called the instructor judge, but for the benefit of the audience, I'll name it as the assisting judge at the Supreme Court. And he's also a PhD candidate at the University of Sao Paulo. Uh, Ms. Priya Baranwal is a former judicial magistrate at the Bihar Judicial Services. She served in the district judiciary for about 6 years before coming here to the Columbia Law School. She was also an assistant registrar research at the Research and Planning Center, the Supreme Court of India. And as a part of her role there, she's been deeply involved in researching or working at the case flow management committee at the Supreme Court of India and various other reports. So, thank you so much, guys, for joining me here. And I'm looking forward to this conversation. Thank you.
Thanks, Shashwat.
So,
Thank you. It's a pleasure to be with you guys.
thank you, Michael. And just to begin the conversation, I just want, for the benefit of our viewers, let us go through the process of, selecting judges in your respective jurisdictions. What is the pathway to becoming a judge in your respective jurisdictions? For example, is it an examinations-based system, which involves an examination followed by an interview, let's say, and then judicial training before you join the bench? Or is there some other process involved, which involves, uh, having some kind of practice or some minimum years of practice before you becoming a judge, and then you're handpicked by the judiciary? So what is the pathway to becoming a judge in your respective jurisdictions? And Michael, if you could also explain what are the differences between the state and the federal judicial system in Brazil, and how did that shift happen for you from the state judicial system to the federal judicial system? Michael, you can start first. Yes.
Okay. So I was informal at first. It's because of our practice in Colombia. I use it to you as my fellow colleagues at the university. Uh, Regarding the selective system, we in Brazil have exams. It's a public selection. Uh, that's a very serious concern for us because of our past, where we had a king and people could get the jobs by indication, by coming from rich families. So it was a problem. So now it's open for everybody. Of course, better educated people will have better odds to get there, but we have a public selection. Now we have some quotas for African descendant people, and we have selection for all trial judges. We just have some political appointments for Court of Appeals. We call it 1/5 rule. 1/5 of
Okay.
all Court of Appeals are selected by political indication from attorneys and
Mhm.
district attorneys, like private counsels and district
Right.
attorneys.
Right.
And I was a state judge at the state of São Paulo. I loved the job. It was different. Like in Brazil, the state judge has more contact with daily law, like
Mhm.
contracts and neighbors that had a fight, or
Okay.
people that went on a fight on a club, or
Mhm.
maybe a car accident. And you go to the federal courts, we have different cases. We have a lot of fiscal cases, tax cases. We have some regulation concern and federal crimes, of course. It's different from the
Mm-hmm.
United States, but we were
Mm-hmm.
inspired by their system.
Mm-hmm.
So, for instance, just the federal government, just the Congress can pass um, statutory criminal law.
Mm-hmm.
So when state courts trials for state crimes, they are using federal law.
Mm-hmm.
That's a major
Right.
difference.
That's very interesting. And Priya, if you could share what it's like in India.
Yeah. So in India, the process is quite simpler. For trial judges, like at the entry level, there is an exam. Earlier, there used to be a mandatory litigation experience, but in 2002, Supreme Court did away with that experience requirement. Like
Mm-hmm.
I got selected just by writing an exam with no litigation experience
Mm-hmm.
beforehand. There is a three-tier exam, which is an MCQ multiple choice question, then a mains a subjective question, and
Mm-hmm.
an interview stage. And
Mm-hmm.
you clear the exam, you undergo 1 year training,
Mm-hmm.
then you join the judicial services. But now the
Mm-hmm.
Supreme Court has changed this and has
Mm-hmm.
required, now it requires a mandatory period of 3 years of uh,
Right.
ad, experience as an advocate to be a
Mm-hmm.
judicial officer, and then you clear the exam and undergo that
Mm-hmm.
1 year training. So now
Mm-hmm.
it has changed a little bit. It requires
Right.
3 years experience as a lawyer.
Right. Just to follow up on that, Priya, you mentioned that the Supreme Court recently changed this. In your experience, because you served for about 6 years, and you said that you had no litigation experience before you joined the bench, and you came in with judicial training. So, what are your like from your experience? Would you think that this is a beneficial move, or uh, should there be some experience, not 3 years? But what's your view on this?
So personally, I feel like now, like I can get selected immediate. Somebody can get selected immediately after college,
Hmm.
immediately after graduation, versus now there is a 3 years experience, but the age of
Right.
retirement is the same. It's 60
Right.
years. So
Right.
your chances of getting elevated to high court or promotional aspects are also
Right.
affected. This is
Right.
one side. The other thing
Mm-hmm.
is, I do not really think that it will make a huge difference,
Mm-hmm.
because what's more important is the 1 year training, how you get
Right.
trained. Because in the training process, half of the training happens at the judicial academies, and half
Right.
other half happens with the judges alongside on on the bench. So I
Mm-hmm.
think that matters more. But
Right.
having said that, I don't think like any additional experience,
Mm-hmm.
it always adds.
Yes.
So, but for me, I do not think it will make a huge difference, which is why in 2002 the Supreme Court did away with that experience requirement.
Right.
So there may be a situation, a chance where after 3 years, the candidates, the lawyers are choosing the lucrative private jobs option than choosing
Right.
judicial services. But when they're fresh out of college, there is that zeal
Mm-hmm.
to study for
Yes.
the exams. So I think if I
Mm-hmm.
had a 3 years experience, I would rather prefer higher judicial services
Right.
where 7 years experience is required than losing that 3 years time. So,
Right.
but still, of course, there will be more experience, because on bench, definitely it takes more time for you to understand the difference between the law and the practice, and that will some
Yes.
filled by that experience. But I don't think it's a very mandatory requirement. It affects,
Right.
yeah.
Um. So again, like it's a related question, and it's to both of you. So now you've mentioned what is the pathway to becoming a judge, and just a brief overview of what the system look like. Uh, so when I want to talk to you about your initial experience when you joined the bench from, let's say, studying for that exam, then going to that academy, training with the judges or shadowing a judge, to now, you know, you yourself becoming a judge. What was that experience like? What were the first days like? Because you're now, adjudicating, and it's a very different experience. When we're usually interning, also we're at the law firms or with lawyers or with centers, which are more focused on the advocacy aspect of things rather than the adjudicatory aspect of things. So when you first joined the bench, what was the experience like? Did you feel a huge difference between theory and practice? And how do you cope up with that when you first joined the bench? Priya, you can start with this one.
Yeah, I think it was a huge learning experience when I joined. It is in district judiciary. It is said that the first postings are like learning postings,
Mm-hmm.
so you make mistakes and you learn. But for me, what I really was surprised how law in the barracks in the legislations is different from how we apply it in practice, and how
Right.
lawyers try to play with that. Because
Right.
initially, like a lot of lawyers said, told me that, madam, you do not know, you're new to this. But I thought I know the law. But
Yeah.
then they said, no, it's not how it is done in this district. And when you get
Right.
transferred to the other district, they said, that's not how it is done in this district. But then
Right.
gradually you get a hang of it and you understand that actually
Right.
it is the law which is applied. But in districts, they develop their own practices.
Mm-hmm.
Sometimes, let's say, like adjournments
Yeah.
can be like longer in adjournments, and they say that you cannot fix a short dates, it's not allowed, and all of that. So I think dealing with lawyers is something which I learned a lot. Other than that, one of my seniors told me that when you're on the bench, you have to be in highway mode. So when you're in
Right.
highway mode, you have to be very alert, active, and see everything on the road. So
Right. Yeah.
when you're on the bench, you're just not hearing the lawyers, you're also seeing that hopeful litigant who
Yes.
what the litigant is trying to get out of this courtroom experience, the
Yes.
witnesses who are sitting waiting for their turns, the person who is peeping from the window, what is that
Mm-hmm.
person's agenda. Other than that, the court staff, what they're doing under the table, what and all of that. So I think the work is more than just dispensing justice, is what I
Yes.
realized. So
Mm-hmm.
it was a great learn, because I think a lot of training happens on the bench, and you
Right.
learn. I think it is applicable everywhere, that you learn more on the job. So
Right.
and lawyers and prosecutors, good lawyers and prosecutors train you in that journey. So the difference between law and practice and the human relationship with the bar, with the court
Right.
staff, I think that's something which was a great learning experience when I joined.
Right. That's very interesting. Michael, what about you?
Yeah, in Brazil, we had a very similar change, but by legislature. We need a 3-year experience to
Mm-hmm.
get to become a judge. So I had this requirement. I worked for a prosecutor.
Mm-hmm.
She was dealing with penalties, like
Mm-hmm.
they were. She was supervising the jails in some
Mm-hmm.
area of the state of São Paulo, and I was working with her assistant on
Yeah.
this. And afterwards, I worked for a federal judge. So it
Mm-hmm.
wasn't uh, something so different. But I agree with Pri. I don't think the major difference is the 3-year requirement, because
Mm-hmm.
sometimes people will be an attorney for their
Yeah.
father's or
Yes.
mother's office, and it
Mm-hmm.
doesn't make a huge difference. I think the judge trainment is the most important. It's a 3-month
Mm-hmm.
trainment in Brazil.
Yes.
I did it twice, one for a state court and one for a federal court. The
Uh-huh.
second one wasn't uh, so good, but
Mm-hmm.
it was really useful. And when I got to the bench, I think the most great surprise was dealing with people management, the
Mm-hmm.
staff. I
Yeah.
agree with it. It's
That's very important.
something
Yes.
that we aren't prepared as law
Yes.
students. Like, oh, you have to deal with people, you have to manage, and
Right.
you have to deal with a backlog. You have a docket,
Mm-hmm.
and they want from you some efficiency, quality,
Mm-hmm.
but quantity. So you
Mm-hmm.
have to deal with this. You have to balance things so
Mm-hmm.
that you look at your cases not just as numbers, but
Mm-hmm.
lives.
Right.
So that's
That's
the challenge for me. Yeah.
that's true. Some very interesting things both of you have mentioned, and I think that'll really guide us to the next points of our conversation. And in
Shashwat, if I
fact,
may add to what Michael said,
yes.
I think like this thought really occurs to me that if there are like mandatory judicial and litigation internships during your graduation period, that will fill
Right.
in the experience. Like I did not in my university there was no internship mandatory internship
Right.
requirement there, but now it is there, I think. But I think
Right.
that will really fill in for the gap. Like I never visited a district court
Right.
before I became a judge,
Right.
so I wish I did, but
Right.
not mandatorily as a lawyer for 3 years. But
Right.
if I do an internship and learn that with a judge or a lawyer, I think that
Right.
some prepares you to be a better legal professional.
Right.
So it doesn't have to be a 3 year
Yeah.
requirement.
No, I agree. I absolutely agree with that thought that, these internships with judicial internships, for example, should be mandated by the Bar Council, for example, or even let's say internships at the trial level or the
Yeah.
trial court level are extremely important. And I also believe on that similar thought that these internships should be longer, rather than a 30-day period or a 25-day period where people are just coming in. When you start getting a hang of things in about, say, let's say 20, 21 days, you're starting to get a hang of things, of how things work, of how the offices work. It's time to leave. I think at least 60 days, 2 month or a 3 month internship is more beneficial than having three different internships of 1 month each. And that's a thought process that also needs to come in with the students, with the professors or the teachers, and let's say people at the administration level also. And that takes us to the next point of our conversation as well. And from my own experience, I was litigating back home in India for about 3.5 years, at all levels. But I always found the trial courts the most challenging. And I always say this to everyone that, I personally believe that uh, any lawyer worth the salt would be a good trial lawyer. And you really are in the thick of things when you're at the trial court. It's a much more human experience, let's say, because uh, there's a lot of human element involved at the trial courts level, because it's the original litigation that's happening. Facts are coming in for the first time, witnesses are coming in for the first time. You're, let's say, building a case and you're adjudicating a case for the first time. So, along those lines, since you both were at the trial level for a quite, number of years, what are the unique challenges, let's say, associated to trial courts, rather than, let's say, appellate courts? In your experience, what are the unique challenges of a trial court system as a judge?
Should I start, Shashwat?
Yes, yes, yes.
So for me, I think I realized, so in general, there is this public
Mm-hmm.
perception that justice is delivered by judges, and therefore, if
Mm-hmm.
there is a delay or if there is any lacuna, it is on the part of judges. So this is what I realized, that justice is a collaborative exercise. So
Right.
as a judicial officer, as a judge, somewhere
Mm-hmm.
you have to collaborate with the law enforcement, with the
Mm-hmm.
bar, with the prison authorities, with the forensic departments, and of course also with your supervisors, the district judges. And um, I think that if there is a lacuna, if there is a issue with their performance, somewhere it affects your own performance. So to be able to work in that environment, I think that was very unique for me. But when
Mm-hmm.
it comes to what was your question again, Shashwat?
What are the unique challenges associated to a trial court, in India, for example? What
Yeah.
is it dealing with the court staff, the heavy caseload that a trial court has to face, a trial court judge has to face on a daily basis? Sometimes the witnesses don't show up. Sometimes,
Yeah. Yeah.
and we're guilty of this as lawyers also. Like sometimes applications are filed, let's say, not for, let's always good reasons. These applications have a delaying, tactic involved in them, for example. How do you deal with these situations? Are these challenges you faced?
Yeah. So I think
Yeah.
like there's this saying in district judiciary. One of my seniors told me that the real court work starts when the judges leave, and I was so
Right.
surprised. Like, how is it even possible? Like, we leave at 5 p.m. in the
Right.
evening, and that's when the court work starts. So
Right.
that means that what it means is that there is a big collusion between the court staff and the
Mm.
lawyers. Because every three
Right.
years as judges, we get transferred, but the court staff
Right.
and lawyers remain there. So to
Right.
break that collusion is very difficult for a judge, and it is
Right.
important somewhere to get ahead of that.
Right.
So I think that was a challenge for me.
Mm-hmm.
Other than that, of course, I think as lawyers, I understand that lawyers have to cater to
Mm.
the client's
Client.
interest. But
Yeah.
somewhere, I think as part of judicial curriculum, this should be a
Mm.
part that it's not just your client interest, you're also furthering the ends of justice somewhere. So lawyers
Right.
who try to mislead the court or even lie at times, try to manipulate the courts, I think that is one practice which was a big challenge for me, because then
Yeah.
the reliance aspect on the bar somewhere gets affected.
Right.
So that was a challenge, because initially in my initial period, in my initial years, some lawyers even tried to emotionally manipulate me. That
Yeah.
if I can share an example, like when you're
Yes. Sure. Sure.
granted, yeah, when you grant bail, you require bailers, which is like
Mm.
sureties for who can assure guarantee for the accused person to appear in court.
Yeah.
And in district judiciary, especially in Bihar, there is this practice of forged bailers, false,
Right.
bogus bailers, as they call it, which is like
Okay.
there are some people roaming in the courts who get paid a very little amount of money to serve as bailers, because not
Okay.
everybody can afford find a bailer who's
Right.
related, or if
Yeah.
one cannot find a bailer, you have a ready bailer. There is a
Yeah.
bus of bailers which comes to court. So there is
Okay.
this exercise happens. So we are
Okay.
trained to not really encourage that practice. So we
Mm-hmm.
really understood, okay, these bailers I know are forged. So we used to call
Right.
it a lot. So once
Mm-hmm.
I called it out and asked the lawyer, no, I won't accept these bailers, get me genuine bailers.
Right.
So I was really angry that why my judicial time is getting wasted in deciding
Mm-hmm.
whether they're genuine bailers or not.
Right.
And with the next day, the lawyer came to me and said, Madam, you scolded that bailer so much that the bailer
Yeah.
died.
Oh no.
I was
Yeah.
like, oh my God, was
Yeah.
I wrong? And that was like my first year as a
Yeah.
judicial officer. I was shocked that did I do something
Yeah.
wrong? Maybe I shouldn't have scolded and everything. And I
Yeah.
really got disturbed and could not perform my duties well
Yeah.
with like immediate an hour. And
Yeah.
after that, the lawyer came, Madam, the bailer is all fine. I
Yeah.
was just joking. So
Mm-hmm.
I think somewhere
Yeah.
there is a need of a sensitization, the
Yeah.
sensitivity in lawyers to.
That's true.
I don't think that your client's interests and justice interests are conflicting. They can be
Yeah.
one. So that
That's
was
true.
a challenge somewhere to deal with lawyers and to rely on them. So that's
Right.
one. Other than the lawyer court staff collusion,
Yeah.
because there were good lawyers also who I am even in
Mm.
touch with, and I even discuss legal
Right.
issues academically. So,
Right.
but then I think the misleading part, the that is some
Yeah.
was a big challenge for me.
That's very interesting. That's a very unique thing that you've told me today about the Bihar judicial system as well. And Michael, how is it like for you? What are the challenges that you face as a trial court judge?
We also have this kind of problem with conflicts,
Mm-hmm.
and even conflicts between defense counsel and district attorney, the prosecutor,
Okay.
and the
Mm-hmm.
counsel. Sometimes I had to
Mm-hmm.
interview them and to listen to them. That's better.
Mm-hmm.
To listen to them and try to understand what was happening so that we didn't have a major fight in the hearing. But
Mm-hmm.
we also have a lot of problems about expectations about being efficient.
Mm-hmm.
Like the higher courts expects from us that we are fast and we deal with our staff
Mm-hmm.
uh, like in a very polite way that we can lead them to bring a great public service, and it can be very challenging.
Mm-hmm.
We deal with witnesses and victims,
Uh-huh.
so we are very close to community. While
Mm-hmm.
the higher courts are in the big towns, in the big cities, we are in the
Mm-hmm.
small town. We are talking to people, we are living in that
That's
community.
true.
So
Yeah.
we got the first impression of justice for a lot of
Mm-hmm.
people. So that's a great responsibility. People will look at you, people will see how you drive your car, if you
Mm-hmm.
drink, if you don't drink,
Mm-hmm.
where are you going?
Right.
So that's different. So you have a role inside the community, not only when you are in court. And We also have a large number of cases. I've talked to
Mm,
Priya about this, and I've understood that both countries have this problem. Like a lot of
mhm,
cases, it's different from the United States. Like we
mm,
have a great number of criminal cases, of civil cases, and
right.
of lawsuits, and you have to deal with this. Like you have to manage this docket so
Mhm,
that you get a speed answer to that community. I think that's
mhm,
I told about it, but it's a
right.
great challenge.
Right. Um, Both of you in your answers now and previously mentioned about backlogs and efficiency and increasing efficiency, and catering to the society and community at large as judges. There's a huge role of judges in that. So now I'm going to the topic which I think is a topic which we often talk about. It's a topic which is discussed, let's say, at every conference in India, abroad, United States, anywhere you mention it and it's discussed. But it seems like there's no uniform solution that can be found to this. Uh, but let's talk about backlogs and the caseload. Uh, in your respective opinions, and let's start with what is the situation, Michael, for you. Let's say in Brazil, how is the judicial backlog, right? Case backlog, for example, like is the is it a huge docket, or are there a lot of cases still pending? And two, what, in your opinions, what are the major reasons behind this? Is it the lack of judges, or so to speak, that more judges should be appointed to the bench, or is it also attributed, or let's say attributable, for example, to lawyers and their tactics, let's say of repeatedly seeking adjournments or misusing the procedure in some forms, or the files, or the digitization of the files or the records not being kept in a proper manner, that sometimes they're misplaced, or sometimes you have to go back in time and then find some papers? Is this a combination of factors? What are the reasons like?
Oh,
Michael, you can start. Yeah.
there are a lot of factors,
Yeah.
and we have improved. Like in pandemic times, we got digital, so
Mm-hmm.
now we don't have paper on court, so
Mm-hmm.
it was an advancement.
Mm-hmm.
Now we don't have employees like stapling a lot
Mm-hmm.
of papers and organizing a lot of
Right.
copies. It's over now. It's better now. You
Right.
can focus on analyzing that document and not
Right.
just
Right.
administrating a lot of copies and, oh, where is this paper?
Mm.
And we have other factors, but I don't think that we need more judges because there's a cost, and we are
Mm-hmm.
not a rich country, so we should not spend so much on
Right.
the judiciary. We
Right.
already have a high cost,
Mm-hmm.
so we should work better. And some factors we have in small courts claim,
Mm-hmm.
in small claim courts, but in other courts also gratuity. I think
Mm-hmm.
that's a blessing and a
Right.
problem because
Right.
when you have gratuity for everything, people can make uh, very strange requests, uh,
Right.
requests that have no chance of getting something from the judiciary, but they do
Right.
that because it's free,
Right.
because there's no loss.
Right.
You are not betting, you know?
Right.
So it's a problem. So we have a major backlog because of this. And we also have a problem that's from the government, the
Mm-hmm.
executive. Because
Right.
sometimes the court will say, oh, we won't accept this kind of decision
Right.
from regulatory agencies or
Mm-hmm.
from administrative organs or institutions, and they will keep doing it.
Right.
They will go on and on and
Mm-hmm.
on, and this case will return to the judiciary each
Mm-hmm.
time a citizen goes to the executive and makes the same request. So
Right.
it's the state given work to the state. It's the
Right.
same. Like
Right.
I can tell you like, oh, uh, another institution is giving me work. No, it's the
Right.
same. It's government. Like
Right.
it's public institution. So we
Right.
should solve that.
Mm-hmm.
But we already have some mechanisms. For
Mm-hmm.
instance, we have in the trial court some use of artificial intelligence, not to
Mm-hmm.
decide the case, not to adjudicate, but to
Mm-hmm.
make the case law, how
Mm-hmm.
can I say, go forward,
Right.
like to um, send an email to the attorney. Oh, now it's your time to defend your client. So
Right.
that's great. And in higher courts, we are a civil law tradition. And to finish my answer, I should say
Mm-hmm.
that they are using some precedential system to
Mm-hmm.
make things simpler.
Mm-hmm.
And now we have like some appeals that can be analyzed together. And now we
Mm-hmm.
have a precedent. Now you have
Right.
to follow this.
Mm-hmm.
So the case will return to the trial courts and
Mm-hmm.
everybody will follow it and it's efficiency.
Right. Priya, before you start, 2 minutes. Priya, what are your thoughts about this?
So, like Michael said, there are a lot of factors why there is backlog. First, being human resource, of course, we talk about lack of judges, lack of court staff,
Mm-hmm.
even lack of prosecutors, lack of good lawyers. That is there 100%. Like when I joined, I was my own stenographer, I was my own deposition writer. So, and even the staff for that matter, I should have had 6 people with me who as a team, but there were just 2. So they are also overburdened, which nobody really talks about. So that
Right.
is there 100%, and there are infrastructural gaps for sure. But
Right.
it's keeping all of that aside. I think the major issue, which I feel is, I think is
Mm-hmm.
just doing your job well. I
Right.
realize that that is the reason of backlog sometimes, because let's say, for instance, the most delay that I felt was there in during the
Mm-hmm.
process of trial was to secure the appearance of the
Mm-hmm.
accused or secure the appearance of a witness.
Mm-hmm.
So if, let's say, if you serve the summons, serve a process to secure the appearance of the accused, I cannot
Mm-hmm.
move to a stricter process, which is a warrant, until I
Right.
have a service report. Service report is
Right.
a receipt that the summons was served to that person. So as a judge,
Right.
I cannot move ahead until I have that service report. So
Right.
logically, the process server should take the
Mm-hmm.
summons, immediately serve it, and get the service
Right.
report as and immediately as it was served. But we
Right.
do not get service. Like I have rarely had service reports, and
Right.
we are bound to jump to the next warrant, like next process, without even getting the service report. So if the
Right.
process server gets the service report, and sometimes there is the court receives the service report, but the staff has this ulterior motive to not keep the service report on the record. So,
Right.
I think the major
Right.
problem is doing your job well, even as
Right.
judges for that matter. It's not just the problem of
Yeah.
court staff or law enforcement. Judges should be
Right.
punctual. You have to be on the
Yes.
dais from 10:30 to 4:30, like
Right.
pass timely orders. I think if
Right.
everybody does their job well, you
Right.
will see a change, even with
Right.
less infrastructure, even with lesser human resource. I think you can the system will see a change. But the major problem for the backlog of the 47 million cases pending in district judiciary, and
Mm-hmm.
if everybody does their job well, it works. Because
Right.
I can also give another example. If a witness turns hostile to the prosecution, let's say, so what
Mm-hmm.
happens when the witness turns hostile? The prosecution
Right.
cross-examines that witness, that
Mm-hmm.
you are turning against the prosecution, so let me cross-examine. But I've seen like prosecutors giving up. Like, since
Mm-hmm.
now the witness has turned hostile, what is the point of cross-examining? So
Right.
that's when judges play a participatory role, and then they fill in those gaps and ask
Mm-hmm.
inquisitorial questions. And so for me, I've realized that if everybody from judges to court staff to lawyers, prosecutors,
Yes.
law enforcement, if they do their job well, whatever the duties assigned to them, the system will see a change. So the reason of backlog is that simple.
That's a very important point you make. I think what happens is that for a lay person, and let's say for me, even as a litigant, if I was a litigant, for me the only thing that matters is, am I getting a fair hearing? Is my dispute being resolved fairly? And is it being resolved in an efficient manner? I don't want to wait for 10-15 years to get justice, because at one point of time, when I reach that state, that becomes a very blur concept to me. That stops mattering. I lose the concept of what is just now, or does this even matter? So for a lay person to, be on the outside, and they're very fair on their part to say that we need more judges, it's always the judiciary, but there are so many leakages within the system, that only when you're practicing, or when you're a judge, or when you're a counsel or course, that's when you realize that there are so many leakages within the system, so many procedures within the system, not strictly mandated by the statute, but let's say by the court rules and all that, that actually cater to that delay, or that provide gaps or openings for people to exploit that procedure, for incentivizes them to exploit that procedure for ulterior motives. I think that's the biggest reason, which we need to focus on. And as we talk about efficiency, and we've talked about digitization of records or e-filing, and the court record becoming digital in Brazil and in India. So let's also talk about virtual hearings or online hearings. When COVID hit, across the world, virtual hearings were implemented, online hearings were implemented, and now they've become a trend or a norm. And I think on an accessibility basis, it has improved accessibility to a lot of extent. But there is some, debate between accessibility and fairness of proceedings. So what are your, respective views on virtual hearings or online hearings? And do you think they're helpful? And what is the balance that we need to find? Priya, why don't you start with this one? Yeah.
So I was posted in like not very developed districts in Bihar. So the
Mhm.
issue, I think the virtual hearings is for sure helpful, and but they matter more at the stage of at the levels of high courts and supreme courts, where the litigants and the lawyers especially are well trained
Mhm.
and they're well versed with the technology and everything. But when it comes to district judiciary, I cannot say the same for other states like Delhi or Rajasthan, but for
Mhm.
Bihar especially, I would say that uh,
Mhm.
during COVID, we struggled with simply having the devices to
Right.
conduct the virtual hearings with. So
Right.
sometimes my office clerk is taking out his phone and just calling the lawyer who, or even calling the accused or
Yes.
witnesses for that matter, for that virtual
Mhm.
hearing. Like sometimes even
Right.
I encourage virtual hearing a lot, because sometimes what happened, let's say there
Mhm.
are five accused persons and we are at the stage of charge framing, and there are four accused persons in front of me.
Right.
The fifth person is missing, and the
Right.
fifth person may be sick. So usually the judges adjourn that
Right.
the case, because the charge cannot be framed like separately.
Right.
But what I used to
Mhm.
do was I this is not statutorily or fair in
Mhm.
the strict sense of the term, but the
Mhm.
the my court staff used to call the accused person, and then I used to frame
Right.
the charges by taking the person, like securing his personal appearance virtually. So 100%
Right.
cases can move faster with virtual hearings.
Right.
But having said that, I do not think that, especially in backward regions, in villages, the
Mhm.
litigants are well versed with technology. Sometimes they don't even have a smartphone. So that's when
Right.
training of lawyers and lawyers embracing technology, being open to virtual hearings, I think that part is more important when it comes to district courts. But of course, virtual hearings is a reality in high courts and supreme courts. They're using it on a daily basis.
Right.
There are e-filings. There is a link where you
Mhm.
can always join the courts. There are even live
Right.
streamings. But when it comes to
Right.
district judiciary, it's also a little complicated, because in virtual hearings,
Right.
how do you present a document if there is an evidence,
Right.
a documentary evidence? How do
Right.
you present that? So there are guidelines for that, for presenting documentary
Right.
evidence and everything, but it's not as easy as
Right.
it looks. So
Right.
it's always better to, maybe if the,
Yes.
especially in district judiciary, if they come to court,
Right.
but if we can fill in that access to justice gap by a virtual hearing, I think judges should be
Mhm.
open to it and go out of the way to have
Right.
get that done.
Right. And Michael, what about your views on this? Yeah.
Oh, I love technology, so I'm in favor
Mm.
of screening hearings.
Mm.
And I will tell you something, like before pandemic, when Brazil just could have presential hearings.
Mhm.
So when I had to hear a witness that lives far away, and we have this
Mm.
problem in Brazil, I think you'll have the same problem in India. Like
Yeah.
maybe they don't have this problem in Singapore or
Mm.
Monaco,
Yeah.
but in
Uh,
great territories, we have this kind of problem. And sometimes I had to hear a witness from São Paulo, and I was in the state of Minas Gerais, and I had to send a document to the other judge, and the other trial judge
mm.
would hear the
Mm.
witness and would write it
Mhm.
down or record it, and then send to me, and then I would conduct another
Mm.
hearing, and I
Mhm.
would
Mhm.
consider the witness that
Right.
wasn't there. Like, I don't like this
Mhm.
idea, you know? Now I can hear the
Yes. Yeah,
witness
that's true.
whenever she or he is. And I can
Yeah.
even hear the witness inside the counsel's office. So when this
Oh,
person does
yeah.
not have a cell phone, I would say that in Brazil it's
Right.
very common to have a smartphone now. Nowadays,
Mhm.
not in the past, but nowadays,
Yes.
even in the Amazon rainforest. I have to tell this
Oh,
experience. So sorry,
yes.
I'm
Please,
not
please,
linear,
please go
but
ahead.
I have to tell
Yeah.
this. I was in the Amazon rainforest, and I was in a city that's called Altamira, and only the area of this
Mhm.
municipality is bigger than Portugal.
Mhm.
So sometimes I
Mhm.
had to hear a witness, and I would tell my staff, I need to hear this witness. Oh, and my
Right.
staff would say, just to tell this witness that there's a hearing, it will take me four
Yeah.
days of traveling inside the
Oh,
Amazon rainforest. But,
okay.
but I
Mhm.
know this person is a fisherman, and there's a colony of fishermen, and they have a cell phone
Uh-huh.
inside this colony.
Yeah.
I can call the
Right.
the boss, the leader of this community, and he will get
Right.
to the fisherman. So do
Right.
this, and I could hear this person
Right.
with a smartphone inside
Okay.
the colony,
Yeah.
inside the rainforest.
Right.
So
Wow. Yeah.
sometimes the person
Mm.
won't have a cell phone, but there's a cell phone
Mhm.
close to this person. So I think it can work. Like
Right.
when we have pandemic,
Mm.
like the courts that were very traditional about hearing just
Mm.
inside the courtroom, they let us hear people
Right.
outside, and people were
Right.
using the smartphones or notebooks. And I had very speed
Yeah.
trials, and I
Right.
should say that I'm an enthusiast. Like I think
Mm.
it works well, but of course there are
Yeah.
limits. Like I
Mm.
think I'm not sure. I think you have more juries than Brazil. I don't know, but in Brazil we just have juries for
Ah.
for homicide, basically.
Okay.
It's
Mm.
not only homicide, but
Mhm.
basic just for
Yeah.
long story short, it's for
Mhm.
homicide. So for jury trials, I think that's
Mm.
better to be there because you need the
Mhm.
jurors to look at the victim, to the
Mhm.
witness, to look at the defendant, to hear things. So I
Mm.
think jury trials must be presential.
Mm.
But other kind of
Right.
trials, I think this technology helps a lot, especially
Mhm.
when you have a very great territory. And even now that I'm in
Right.
my state, and my state is
Mhm.
more populous, you have roads to
Right.
go everywhere. It's
Right.
easier. It doesn't take 4 days to find a person
Yeah.
inside my city, just 1 hour most. And
Right.
now I have like 14 towns
Mhm.
inside my
Right.
jurisdiction when I go
Okay.
back.
Mhm.
So people don't live in the same city, so they don't have to try to travel to
Mhm.
be
Right.
heard, you know? I
Right.
think
Right.
it's a good idea. I understand Priya, and
Mm,
I respect that. I think
mm,
sometimes you
yeah.
get a better work when you are in front of the person. I
Yeah.
consider this, but
Mm,
because of my reality, especially when I
mm,
worked in the Amazon rainforest, I was
mm,
very happy when I could hear a person that was inside the rainforest and they didn't
mm.
need to travel alongside rivers
Right.
and bridges to come and see a judge.
Right.
They can
Right.
Yeah,
really,
even I think
really,
like you don't have to come to court for everything. Charge
yeah.
framing
Right.
or even appearance can be secured virtually. A lot of physical appearance
Right.
can be cut down, and that will expedite the process.
Right.
But
Right.
I think to make that a reality, it takes
Right.
time, it needs
Yes.
infrastructure, it needs like even as
Yeah.
basic as regular supply of electricity. So, which so these are certain
Yes.
issues that I
Right.
have
Right.
faced personally. I cannot say
Yeah.
that's true for the whole
Yeah.
of the country, but
Yeah.
that's an issue at least in some districts.
Can I just add
Yes.
something?
Please,
I agree
please.
with you,
Yes.
but sometimes people that lives in rural areas, they will
Mm-hmm.
travel to their attorney's office because it's
Mm-hmm.
closer.
Yeah.
They
Yes.
don't have back home that like they live in the farm, but they will go to
Mm-hmm.
the city that's close. The lawyer is
Mm-hmm.
there, so he can turn on the computer and they don't have to go to the city where there is a federal court.
Yeah.
So
Right.
it still helps, you know.
Yeah, that's
That
true.
that's what I
Yes.
meant. Yeah.
Oh,
In
got
the
it.
case of
Right.
in my case, yeah.
Yeah.
Right. Yeah. I think these are very important issues. And, Priya mentioned, and I would have to contribute to this that forget about, let's say, the more remote or the rural parts. I've seen in major cities as well, judges being very hesitant to implement that technology because of this reality that most people don't have access to proper internet, or they might use it to evade the system as well. So it also, there's a need to adapt to this system. This is very new for everyone. So, and while we are on the topic of technology, I would want to close it by asking about, artificial intelligence. There are debates going on around the world. In fact, there are pilot projects in certain jurisdictions where some of the cases are being delegated, let's say, to an AI, to an artificial intelligence system for them to adjudicate very small cases, let's say parking, or these traffic violations and all, that are being delegated to artificial intelligence. So my question is, it's a combination of questions which is folded into one. Are you in favor of delegating any sort of adjudicatory function to an artificial intelligence? And two, what do you think, like, where can artificial intelligence be helpful to judges? Michael, why don't you
So
start with this one?
I'm eager to use technology in favor of jurisdiction,
Mm,
but I have my
mm,
issues about artificial intelligence, like intelligence.
yes.
There's a
Mm,
professor, a Brazilian professor, that used it
mm,
to teach at Duke University in the United
mm-hmm.
States, and
Yes.
he tell us that it's not intelligent
Mm,
and it's not
mm,
artificial, like it's just a
yes.
machine, and
Right.
that's something very specific. He's a
Right.
genius, so I won't try to explain this. It's just
Yes.
a critic about the
Mm-hmm.
system. I like artificial intelligence for some usage, like when I'm
Mm,
researching some issue, I can use
mm,
artificial intelligence to
right.
find the right paper that
Mm-hmm.
I will read. But artificial
Right.
intelligence will find it for me. I don't want
Exactly.
it to
Yeah.
read for me, just to
Yes.
find it, you know?
That's
So I
right.
think we have to take care about it. You will
Right.
have the wrong answers from artificial intelligence. And
Right.
sometimes I was discussing with a colleague, our
Mm-hmm.
colleague in Colombia, a very intelligent colleague, and he was talking to me
Mm-hmm.
like, "Oh, I would like that trial judges would be replaced by
Mm,
artificial intelligence. It would be not expensive, fast, and
right.
predictable. You could
Right.
have foreseeability and a strong presidential system." I disagree
Right.
because if
Right.
you just feed artificial intelligence and decide this case for me, it will adjudicate
Mm-hmm.
the cases looking to the past. Like in the United States,
Right.
we were still with
Right.
separate but equal doctrine. Can you imagine that? That
Right.
like it's unacceptable.
Right. That's
So
true.
you have to evolve
Yeah.
within society, and the judges live in this society.
Mm.
They can feel what society
Right.
needs, what society discusses,
Mm.
what are the problems of society. I'm not telling that I should
Mm.
adjudicate cases not considering the statutory law. I'm a civil law tradition
Yeah.
judge, so I
Yeah.
respect that. But even when you
Mm.
interpret statutory law, you have some leeway
Mm.
to make justice inside the
Yes.
society that you live in. You have some ethics
Right.
that comes from living in that community. You have to look at the face of
Right.
the people that you are
That's true.
adjudicating the
That's true.
case of. Like
Right.
you have to live there. Like so,
Right.
you have more than
Mm.
responsibility. You live the the word that you help to create it. I know
Right.
it's a little
Wait.
abstract, but that's
But yeah.
my thoughts.
Yeah.
And
No.
I think that the use of artificial intelligence demands responsibility and
Mm.
concern for privacy. You
Yes.
cannot just share data of people that are on the
Mm.
courts, and artificial intelligence can use this for anything. We don't know. Like we
Right.
know that big techs are using uh, a lot of data for
Mm.
selling stuff to people. Like we
Yes.
open our cell phone and they are looking at what we Google. They are looking
Yes.
at what we are accessing to
Mm.
sell
Mm.
us what they want. So it's very
Yes.
dangerous if they can get
Yeah.
access to public information because people
Yes.
can trust the judicial system and they can
Mm.
send everything there. So we
Yeah.
shouldn't share this.
Right.
So now in Brazil, we are working with this, but the courts are trying to develop their own tools and train
Mm.
people what we should
Right.
do, what we shouldn't. And now
Yes.
I'm just using in my court
Mm.
just as part of the system that all
Mm.
courts are using in Brazil to make the process like tell the lawyer that's the time for the hearing, this kind of stuff, like
Mm.
the
Okay.
procedural
Right. Right.
stuff, not
Right.
adjudicate
Right.
the
Right.
case.
Right. That's very interesting. Priya, what about you?
I think AI
Mm.
can definitely simplify processes
Mm.
and can
Mm.
help courts expedite trials 100%. But having said that, I was speaking to a software engineer who works at a company here
Mm.
in New York, and he told me that the companies have asked engineers to use AI mandatorily to do the programming, to do the
Mm.
coding that they used to do manually. But at the same time, so the AI is doing
Yes.
the programming, but the engineer is sitting to see whether there are any bugs
Mm.
or whether there are any loopholes or any issues with the programming generated by AI. And but so the thing
Right.
is, again, it is even in the engineering field, if there is a need for
Mm.
supervision of AI in judiciary, where it is
Right.
more a human thing, it is a humane, like courts are human entity.
Yeah.
So for sure there will
Yes.
be AI, but then you will always need a judge.
Mm.
But having said that,
Right.
I think for certain cases, let's say for cases like check bounce cases where the checks are getting
Right.
dishonored, where you just have to
Yes.
see the limitation period, that whether the notice has been served, or whether the money has been paid, or whether the limitation has been jumped or something, which really does not need that subjective lens as such. AI can
Right.
decide such cases, but you have to train the model to have that
Right.
standard of accuracy. But it can be
Mm.
done only in these cases which do not need a subjective lens. But
Right.
at the same time, I think that AI can for sure simplify the processes. Like in Supreme Court of India is very open to be
Mm.
using AI. The
Right.
transcription of the proceedings is done by AI there, and they're also
Right.
experiment. There is this technology called there's this application called Supace. It's called
Okay.
what they're trying to do is the AI will do the legal research and the case briefs will get generated
Mm.
for the judges, which the law clerks are doing.
Right.
So, of course, you have to train the model, but the
Mm.
point is that the court should be open to using it.
Mm.
as long as it is assisting them, but you always need a
Right.
human intervention. If it is still there in the technology fields, for sure in judiciary you need humans to deal with people, because like as a judge I can be liberal in a case and I can be strict in a case, but AI,
Right.
for AI it's maths. So
Right.
I think, and justice is not mathematical
Right.
that way, especially in cases like homicides or sexual assault,
Right.
in such cases, which are sensitive in nature. But when it comes
Right.
to cases which are purely objective and can be mathematical, uh,
Right.
there I think AI will do wonders.
Right. That's again very interesting insights from both of you again, and this takes me to the last segment of our conversation, because since you've talked about the human element of judges, I really want to focus on the human side of judges, because for a layperson and even for lawyers, when we're arguing before a judge, or for a layperson when they're viewing a judge, there's always some kind of legacy attached to the bench, and they're unable to focus, or people are unable to focus on the human side of judges. So my question is, how do you deal, let's say, with certain moral dilemmas as a judge? Because of course, sometimes there are very senior counsels. You're a young judge, a very senior counsel who's been at the bar for 35, 40, 45 years, who's coming in and arguing in front of you, saying things like, you're new to the field, you don't even know how this works, and you have to adjudicate that case, trying to sort of bulldoze sometimes the proceedings. Very fair on their part as well. They have to, advocate in a style that, is very persuasive also sometimes. Sometimes there's political pressure. Sometimes there are cases which are highlighted in the media because, there are certain aspects attached to it which are of importance to the public. So, considering all of these things, how do you deal with these things as a judge? Because there are moral dilemmas attached. You have to be fair. You have to, keep your head focused on, have to adjudicate this in a very fair manner and not focus on these things, because I'm sure that these play in your mind. So, how do you do that as a judge? That's my question. Priya, you can start with this one.
I think as a judge, for me, if there is a senior counsel or there's junior counsel, it doesn't really matter. I don't have
Mhm.
that, like I don't have that baggage as like Justice Chand. There is Michael, I think the 50th Chief Justice of India. There is he's Dr. Justice D.Y. Chandrachud.
Mhm.
He said that he was against using the term lower judiciary, or uh, instead of rather using district judiciary, like even using judicial officer, like everybody is a judge. It's not a senior or junior. Similarly, for me, senior counsel or junior counsel, of course, there is respect, but you have to respect the seat where you're sitting, and justice is not that, it cannot be hierarchical in that sense. But of course, there have been moral dilemma, especially in whenever I decided bail applications, uh,
Mhm.
because let's say if a case is triable by the sessions court exclusively, the
Mhm.
general approach is that judges simply reject the bail application, saying that the offenses are grave and therefore the
Yeah.
application is rejected. And the reasoning is fair. The reasoning is that even as part of training, one of the senior judges told me that you preserve yourself first and then you deliver
Mhm.
justice. Because if you
Mhm.
start taking risk with serious offenses and grant bail,
Mhm.
somewhere there will be allegations against you and all of that.
Right.
But there were also judges who said that be fearless and
Mhm.
decide the case on the basis of merits of the case. So the
Right.
merit of a lawyer is more important for me. The merits of the case are more
Mhm.
important, but at the same time, judges are humans and they need
Right.
a place to go to. And a legal profession in general, as a lawyer or as a judge,
Right.
it's an academic profession. It is a discussion led profession, like what we are doing here now.
Right.
So even judges, like when I in during my initial period on the dais, if I was confused what to do,
Right.
after court hours, we used to sit with fellow judges and discuss what would you do, and even discuss with senior judges. Even senior judges, like experienced judges, discuss among themselves what they do. So I think that
Right.
judicial fraternity is very dear to judges. And I
Right.
wish there were a Reddit for judges too, where they can just
Right.
anonymously type their questions, ask their questions, and have answers. Because, like on
Right.
an all India level,
Right.
there are very less exchanges. We are very limited to our own districts and all of that. So
Right.
it'd be great to develop like a judicial fraternity, even going
Right.
abroad internationally, because the problems are quite similar. uh,
Right.
everybody's talking about more or less the same thing, despite that the system is different.
Right.
That, and I would also say that, like in one of my seminars that I
Mm,
attended in the semester at Columbia Law School was
mm,
access to civil justice, and the
mm,
professor, what he does is there is something called tiny chats. You can just Google and find
right.
it. So in tiny chats, what he does is he talks to judges on a personal level, like what they
Okay.
like in life, in
Mm,
personal life, and
right.
the judges are showing their human side than just the judicial side, and that somewhere makes litigants see that judges are also humans and they're also dealing
Hmm.
with certain issues.
Right.
Besides, I think one thing that came as a surprise, I think it's a very long
Right.
answer, but just one last thing I would want to add. A judge,
Mm,
especially in India, be it at the
mm,
district level or the Supreme Court level, is not just deciding cases. This I did
right.
not know until I came,
Mm,
joined the profession. So,
right.
in India, what happens is judges also
Mm,
render administrative function.
right.
So, for instance, I came to know in New York there is something called CAC, I
Mm,
think Child
mm,
Advocacy Center, if I'm not wrong. And the purpose
mm,
of that center is to record interviews of sexual assault victims, especially
right.
children. And that is done by judges in India, which is,
Right.
I think, Shashwat, Section 164 of CRP.
Yes.
Which is, we record those statements, and those statements require a lot of sensitivity, and it takes a toll on your own
Yes.
emotions as well.
Right.
So that, as well as that, you also conduct whenever there is a
Mm,
custodial death in jail
mm,
or in a police station
mm,
in a lockup, the custodial death
mm,
inquiry is conducted by judges. Whenever there is a corruption charge against a court
mm.
staff, the
Yeah.
inquiry, the departmental proceedings is conducted by judges. Apart
Yeah.
from that, like during my period at my in my posting at Gaya in Bihar, I
Mm,
served as the drawing and disbursing officer, which is the DDO.
mm,
Basically, what a DDO does is that any expense that is made for the court, be it salaries of
mm,
judges, allowances, or even the paper that you purchase, that is
yeah.
done by the signature of the DDO. So that was
Right.
additional responsibility other than the judicial responsibilities.
Right.
So I think that part is not out there in the society and
Right.
needs to be told. So
Right.
very responsibly, though, without uh, opening the judges' lives and without
Yes.
messing up with the partiality and all of that, like messing with
Right.
their independence. So
Yeah.
yeah, and I think judges share the same spirit everywhere. Like we have so many
Right.
judges as batchmates
Mm,
in our batch here,
mm,
and we share the same spirit, like Michael and I.
right.
There needs to be more discussions, like tiny chats,
Right.
where we can reveal that we are humans.
Right. That's true. Michael, what do you think?
I think knowledge is very important. You have to know the law, of course,
Mm,
but even if you don't know that specific statutory law or that
mm,
theory, you can study it.
right.
It's not a problem. You have to study to pass the exams. You will have the continuing judicial education for that
Mm-hmm.
to not become outdated, your knowledge.
Mm-hmm.
But there's a scholar's statement in Brazil that
Mm-hmm.
says that those who know only law do
Mm-hmm.
not even know law. So
Right.
you need more than that. You need to
Right.
read other fields. You need to understand the society you are in, like
Mm-hmm.
in my country, about racism, about inequality. You have to
Mm-hmm.
understand these things so that you can adjudicate the case, and you need a lot of emotional intelligence. Of course,
Right.
we are not perfect, we are human, but we are
Mm-hmm.
trying to develop this. Like in most of cases, I don't feel a lot of pressure,
Right.
but I already worked on the most valuable case in Brazil and maybe
Right.
the world.
Yeah.
Some people would say three in the world, ranking it, but it
Mm.
depends on your view. Some say it would be the most valuable lawsuit
Yes.
in the world. It was a dam break in Brazil for a
Mm-hmm.
multinational company,
Mm-hmm.
international company that's based in Australia, United
Mm-hmm.
Kingdom, and Brazil. It
Mm-hmm.
was huge, and I was deciding the case, or I had a hearing, And then I was heading home, and people would say me, "Oh, they are telling about this in the news." And
Mm.
I arrived home and I turned on the TV. Oh, they
Yeah.
were talking about it. So it
Right.
was a lot of pressure. So you have to breathe, to have
Yeah.
your friends, to have your family, forget all that.
Yes.
And more than being partial, more
Mm-hmm.
than be just, you need to have this appearance.
Right.
People have to trust the system. So you
Right.
have to take care of your appearance, of what you
Mm-hmm.
do, because even if you are very serious, you have
Yes.
to give this appearance to people more than
Yes.
just be. So that's a big concern for being a judge. So
Mm-hmm.
I think it's not only about knowledge. You
Mm-hmm.
have to know the society you are in. You
Mm-hmm.
need to read more than just law. Like if
Right.
you just read law, you can't
Right.
adjudicate a case.
Right. I think that's an extremely important thing that you've said, Michael, that you need to broaden your knowledge fields. You need to read about economics, politics, sociology, psychology, everything that has an impact on the law, that plays a role in the field of law. One should study about that. And Priya, as you've mentioned, we need to focus upon the human side of the judges as well. There should be some kind of judicial fraternity. That should be, these are very, very important insights. And with that, I think we've come to an end of our conversation. And this was a fantastic conversation. I'm very, very thankful for your insights. There were some great answers in there and some very, very unique experiences that you have shared. So, thank you so much for joining us today. And any concluding remarks that you may have, and we can close this conversation.
I think I'm
Thanks for
glad that,
having
yeah,
me. Sorry.
yeah.
Mm.
Go ahead, Michael.
Thanks for having me, and thanks, Priya,
Yeah,
for this discussion. It was awesome. I learned a
yeah,
lot. Thank you.
yes. All right. Mike has done his part. Priya, if you can conclude as well, and then we'll end the conversation.
Yeah,
Yeah.
I'm glad that we could finally do this.
Yeah.
And I think we need to have more discussions. There are so many
Yeah.
judges.
Mm.
I think pursuing higher education and academics, and we need to talk more, be it lawyers, be it judges, even in academies, I think like judicial academies where trainings are imparted, we don't
Yeah.
have that kind of an exchange which
Right.
is required. And we learn a lot. Like I always learn from Michael, and
Yeah.
so inspiring to have know his journey, how he approaches an issue,
Yeah.
and it was great. Yeah. So thank you.
Right.
Thanks, Michael. Thanks, Shashwat. Yeah.
Thank you, guys.